the Supreme Court just handed down one of the most dangerous, contested, bitterly divided decisions in recent memory. And I'm not exaggerating when I tell you that what happened behind those marble columns is going to reshape American law, American democracy, and your life in ways that most people are still too stunned to fully comprehend. A 5-4 split, not a landslide, not a coalition of justices spanning ideological lines. A bare majority, 5 justices against 4. And that narrow, razor-thin margin, that's not a sign of judicial restraint or careful deliberation. That's a sign of a court fracturing along the deepest possible fault lines at the exact moment this country can least afford it. The mainstream media is trying to bury this story under their usual partisan spin. But the real story is something far worse than left versus right. The real story is that America's highest court just made a decision so ideologically charged, so constitutionally contentious, and so vulnerable to the political winds that it's guaranteed to ignite a firestorm. And you deserve to know exactly what happened and why it matters infinitely more when you understand that this wasn't unanimous. This was war on the bench, dressed up in judicial robes. If you care about what actually matters in this country, if you want to understand the legal landscape that's shaping your rights, your freedoms, and your future, you need to pay attention to what I'm about to walk you through. Because what happened in that courtroom is going to affect immigration policy, gun rights, voting laws, environmental regulations, and the fundamental balance of power in American government. And the fact that 5 justices had to drag a reluctant country forward against the fierce resistance of 4 of their own colleagues tells you everything about how fragile and politicized our highest court has become. Hit that subscribe button right now. Don't do it for the algorithm. Don't do it for me. Do it because this kind of institutional breakdown gets buried under the noise. And you need a source that will tell you what's actually happening before the spin machine manages to rewrite the narrative entirely. Let me take you back to the machinery that made this decision necessary. So, for the last several decades, nationwide injunctions have been the ultimate weapon in American politics. And I'm using the word weapon deliberately because a legal tool serves justice. This serves power. And here's how it works. And this is the thing that the political establishment doesn't want you to understand clearly. Imagine your side loses in Congress. You don't have the votes. The democratic process didn't go your way, so you don't accept it. Instead, you file a lawsuit. You pick your jurisdiction carefully. You find a federal judge you know is sympathetic to your cause, and that one judge, sitting in one city in one courthouse, issues an order that freezes a law or an executive action across all 50 states. All 50. Every single state simultaneously restrained by the pen of one unelected person. That's not a legal remedy. That's a constitutional hijacking. Both parties have done this. Both parties have celebrated when it worked for them and screamed about judicial tyranny when it didn't. Republican administrations got hit with nationwide injunctions blocking their policies. Democratic administrations got hit with nationwide injunctions blocking theirs. The environmental groups filed lawsuits seeking nationwide blocks on Trump administration rules. Conservative groups filed lawsuits seeking nationwide blocks on Biden administration actions, immigration battles, gun regulations, voting rights, healthcare mandates, almost every major political fight of the last 2. Now was decades has involved at least one side running to a friendly federal court and getting a friendly judge to issue an order freezing policy nationwide. It's become the default move when you can't win through democratic channels. It's become the shortcut to power. And for years, absolutely nothing stopped it. Lower courts kept doing it. The Supreme Court kept issuing narrow rulings that didn't actually solve the problem. And the entire system became more corrupt, more partisan, more divorced from any genuine principle of judicial restraint. Then, on a night that shook Washington, 5 justices decided this had to end. But here's the thing that makes this different from a normal Supreme Court decision about judicial power. Only 5 of them agreed. The fact that this is a 5-4 decision is the most important detail about it. Let that sink in. On one of the most fundamental questions about how power flows in America, on a question about the constitutional limits of federal court authority. The Supreme Court split down the middle, or nearly down the middle, and that split tells you everything you need to know about where this country is headed. When you have a 9-member court and you can only get 5 votes for a decision this major, it means you've got 4 justices who are genuinely, seriously worried about what the majority is doing. It means there isn't consensus. It means there's a real danger that 4 of the 9 people tasked with protecting the Constitution think the 5 are making a terrible mistake. And that's not a sign of strength. That's a sign of a fractured institution making a dangerous play. The conservative justices lined up behind this decision. The originalists who believe in constitutional limits voted to limit nationwide injunctions. But here's what the media won't tell you. One of the most vocal originalists on the bench had real hesitation about the breadth of this ruling. The margin wasn't wider because there's genuine concern on the right about unintended consequences. The 3 justices in the minority, not just Sotomayor, but 2 others as well, filed a dissent. That's not just disagreeing, it's warning, it's raising alarms. And they're not wrong about the dangers. They're just saying that the remedy the majority picked is worse than the disease. They argued that while nationwide injunctions have been overused, they haven't been overused wrong. Some cases genuinely do require nationwide relief because some federal actions genuinely affect the entire country in ways that demand national legal remedies. If you limit injunctions to just the parties in front of you, you end up with a patchwork nightmare where the same federal policy is legal in some states and illegal in others, where one American's rights are protected by a court and another American's are denied. That's not justice. That's inequality baked into the legal system, and the 4 dissenters are right to be alarmed about it. But the 5-justice majority decided the risk of a patchwork system was worth taking if it meant stopping the weaponization of nationwide injunctions. They looked at decades of abuse, at a system so corrupted by partisan litigation that nobody even blinks when a judge blocks federal policy across an entire nation based on a lawsuit from 3 people. And they said, this stops now. We don't care about the chaos that comes next. The chaos of the current system is already here. They ruled that injunctive relief must be limited to the actual plaintiffs, the actual people who sued. So federal agencies can't claim that nationwide relief is necessary just because they want consistency. States can't use a lawsuit filed in one state to freeze federal policy in 49 others. If you want national relief, you need to show that the injury is national, that the plaintiffs actually represent a nationwide harm, that the remedy truly requires a national solution. It's a dramatic, bold move, and it's a 5-4 move, which means it's fragile, it's vulnerable. It's the kind of decision that one justice's retirement could flip entirely. The language coming out of the majority opinion is aggressive. One justice wrote that lower courts have been acting as unelected legislators, imposing policy instead of interpreting law. Another emphasized the traditional limits of equity, the principle that judicial remedies should fit the actual harm. But here's what's remarkable and genuinely concerning. The dissent didn't just disagree about the scope of relief. The dissenters argued the majority is fundamentally misunderstanding the role of federal courts in a system where federal law is supposed to mean the same thing everywhere. How can you have a uniform national system of law if courts can't enforce it uniformly? How do you protect constitutional rights if relief is limited to just the people lucky enough to be parties to a lawsuit? Justice Sotomayor's dissent specifically warned that this decision would create havoc in civil rights litigation, in voting rights cases, in situations where individual harm is the tip of an iceberg of systemic violation. And she's not being alarmist. She's describing a real problem. But the majority said the greater problem is a system where policy gets determined in courtrooms instead of legislatures. And by a margin of 5-4, they decided to blow it up. Now let's talk about what this actually means for your life, because this isn't an abstract constitutional debate. This is about concrete policy that's going to affect you and your community starting right now. Start with immigration. For years, both administrations have fought immigration battles in federal courts, with nationwide injunctions flying in both directions. Federal crackdowns get frozen, state enforcement measures get frozen. All of it on the basis of one judge's order applying across the entire country. Under the framework that the 5-justice majority just established, that back and forth becomes exponentially harder. A state that passes an immigration law can no longer have it frozen nationwide by a lawsuit filed somewhere else. States have significantly more runway to enforce policies while legal challenges work their way through the courts. That's a massive shift in the actual distribution of power over immigration policy. Move to guns, because this is where the decision gets immediately explosive. In practical terms, multiple states passed gun regulations in recent years, and assault weapons, restrictions, background check expansions, red flag laws. In multiple cases, those laws got challenged and hit with nationwide injunctions. Under the old system, one judge could freeze a state gun law across the nation. Under the new 5-4 decision, that's dramatically harder. A state law has to be challenged on its face to get nationwide relief, not just in its application to the plaintiffs. That means states have more power to enforce gun laws. But it also means states could theoretically maintain gun restrictions that are blocked nationwide in other circuits. You could end up with wildly different gun regulations depending on which state you're in. And that's exactly the patchwork nightmare the 4 dissenters warned about. That's the chaos embedded in a 5-4 victory. Elections. This is arguably where the fallout will be most visceral. Election law has been drenched in nationwide injunctions, voting rights challenges, voter ID laws, absentee ballot rules, redistricting fights. All of them at some point running through federal courts seeking broad national blocks. The Supreme Court's 5-4 ruling makes it exponentially harder to freeze election rules nationwide, which means election policy is going to have to be fought in state legislatures and in Congress through actual democratic processes. Or at least that's the idea. But here's the terror hiding in that idea. If the same election rule is legal in some states and blocked in others, do we even have national elections anymore? Do we have a country with uniform voting rights, or do we have 50 separate voting systems? The majority says that's a problem for Congress and state legislatures to solve. The minority says that's not a problem. That's a catastrophe. And they're not entirely wrong. Environment. Environmental regulations have been one of the most active battlegrounds for nationwide injunctions. Clean energy standards, methane rules, water protections, endangered species protections, all frozen by nationwide injunctions at various points. That tool just became much harder to use. If environmental groups want to block a federal environmental rule, they have to do it through more traditional litigation. They can't just find a friendly judge and get a nationwide freeze, which means federal environmental enforcement gets harder to challenge. But it also means environmental protections could vary dramatically by state. One state enforcing strong environmental rules while another allows exploitation. Is that good? The majority says yes. It forces Congress to act. The minority says absolutely not. It guarantees environmental devastation in states without environmental advocates in power. And the stakes here are genuinely different from gun policy. We're talking about the actual habitability of the planet in different regions. The political establishment went into damage control mode the moment this decision was announced. The White House released a statement so carefully neutral, it amounts to a confession. We are reviewing the decision, not welcoming it, not engaging with it, reviewing it. That's the language of an institution that got hammered and is trying to figure out how to manage the disaster without admitting how serious it is inside the Department of Justice. Officials are privately describing this ruling as a legal earthquake. Earthquake, that's the word they're using. Because for an agency that has spent decades using the federal court system as a policy enforcement mechanism, this decision is genuinely catastrophic. They can no longer rely on a single judge to freeze a state law nationwide. They have to actually win in the courts and actually prove their case, actually overcome the majority reasoning about judicial restraint, and they're not confident they can do that consistently across every issue every time. State attorneys general on the opposite side of the political spectrum moved immediately. Within hours of the ruling coming down, multiple state legal teams had filed supplemental briefs in ongoing cases, citing this Supreme Court decision as direct support for their argument against federal overreach. They were ready, and they've been waiting for exactly this kind of ruling because for red states fighting federal policies, they viewed as unconstitutional overreach. This 5-4 decision is a hammer. It says to the federal government, you can't use nationwide injunctions as a shortcut anymore. You have to actually govern. You have to actually convince people. You have to actually respect the constitutional boundaries of your own power. But here's the political dimension that the mainstream media is being dishonest about. This ruling isn't a permanent victory for one side. It's a weapon that both sides will eventually deploy against each other. Yes, right now, in this political moment, the states most energized by this decision tend to be red states, fighting federal policies from a Democratic administration. But that dynamic flips depending on who holds the White House. When Democrats control the White House, it's red state attorneys general using the court system to freeze progressive federal policies. When Republicans control the White House, it's blue state attorneys general doing exactly the same thing to freeze conservative federal policies. Both sides have been playing this game. Both sides have benefited from it. Both sides have screamed about judicial tyranny when it wasn't working for them. And the Supreme Court just told both of them to stop. So you want to make policy, win elections, pass legislation, go through the democratic process. You don't get to manufacture national outcomes by filing a lawsuit in a friendly jurisdiction, except now you have a court split 5-4 on that point, which means the next justice to retire could flip this entire framework back. And that's where the real danger lives, because this isn't a final decision. This is an emergency ruling with no dissent, authored by the majority, making a broad constitutional statement. The case goes back to lower courts, which now have to apply this narrower framework to the actual disputes. And they're going to be doing it under intense scrutiny because every judge in America now knows the Supreme Court is watching. But the Supreme Court is watching as a 5-4 split, which means there's a live possibility, a genuine constitutional danger that in the next few years, when this case cycles back to the High Court for a full merits decision, the court could flip one retirement, one new justice appointed by a president who disagrees with this decision, and nationwide injunctions could come roaring back. That's not a side note. That's the entire story of where we are as a country. We're making fundamental constitutional decisions by one vote margins with no stable majority to enforce them long term. The federal government will undoubtedly push back on this decision. It will look for cases where it can argue that national interests are so compelling, constitutional stakes so high, that broader injunctive relief is justified even under the narrower framework. There will be test cases, there will be appeals, there will be circuit court splits where different federal appellate courts interpret the new standard differently. Those splits will force the Supreme Court back to the bench for a full merits decision. And when they return to this question, you might not have 5 votes anymore. You might have 4. You might have 3. This is the beginning of a long legal war, not the end of it. And the fact that it's happening in a fractured court means the war is going to be vicious and the outcome is genuinely unpredictable. The broader implication here, and I need to state this plainly because it's what the political class is actually terrified of. So for decades, both political parties have been happy to let the federal judiciary accumulate power. It was never supposed to have, they liked it because it was convenient. You could win without actually governing. You could achieve national policy outcomes without winning Congress, without winning state legislatures, without doing the hard work of building democratic coalitions and persuading your fellow citizens. You could just find the right judge, file the right lawsuit, and make policy from the bench. The 5-justice majority just slammed that door, but only by 1 vote, which means it's not actually shut. It's just slammed for now. This decision forces American democracy to function more like an actual democracy. If you want change, you need to win elections. You need to pass laws. You need to govern. The courts cannot be your substitute for political legitimacy. That is harder. That is messier. That will produce outcomes that frustrate people on every side of every debate. But it's what the Constitution actually requires. And a fractured 5-4 court just invoked that requirement with enough force to matter for now. This is a genuine turning point in American law. Whether it holds or whether it collapses depends entirely on the stability of that 5-vote coalition. And given the current state of Supreme Court politics, stability is something nobody should count on. Share this video with someone who needs to understand what's actually happening in this country right now. Because the mainstream media is going to spend weeks debating the political implications without ever explaining the genuine constitutional fragility underneath. This 5-4 decision isn't a triumph. It's a warning. It's a sign that our highest court is operating on the thinnest possible majority on fundamental questions. And the next retirement, the next appointment, the next political shift could reverse it entirely. That's the story. That's the weight of what just happened. Subscribe right now, because this kind of institutional breakdown is going to accelerate in the coming years. And you need a source that will tell you what's happening before the spin machine manages to bury it completely.